Welcome back to Law and Crime, everybody. I'm Jesse Weber, joined here again by attorney Terri Austin, breaking down the biggest live trials and legal stories in the news today. We're going to be live right now in 2 different courtrooms, so let's break down what you can expect. First, we've been live already in day 2 of the murder trial of Scott Nelson out of Florida. Nelson is accused of kidnapping and brutally killing 56-year-old Jennifer Fulford. And what did we learn from day 1? Well, Fulford disappeared from the home where she worked as a personal assistant and nanny. Investigators discovered her body 3 days later in a field, duct tape covering her head and face, her wrists and ankles bound, stab wounds to her back and chest, really horrific. The state, they listed out their evidence against Nelson, including DNA and video of him taking out money from Fulford's bank account using her ATM card. This was shortly after her alleged kidnapping. We saw testimony from police, Fulford's employer, and even her husband. The defense, they didn't present a really clear argument in their opening statement of where they're going to go, other than to explain the rights of a defendant and for the jury to listen to inconsistencies. In a letter to the judge, the defendant announced he plans to testify, but we'll have to see if that actually happens. Also, we're planning on going live any second. I think we can jump in a second here out of Texas. This is the Wesley Mathews case. Mathews was accused of killing his 3-year-old adopted daughter, Sharon. Police say Mathews first lied to them, first stating that Sharon disappeared after he left her outside of his house for refusing to drink her milk. Then, her body was discovered 2 weeks later in a culvert, and Mathews then told authorities that Sharon choked to death when he physically assisted her in drinking the milk. It's alleged that Mathews and his wife neglected and abused Sharon in the time leading up to her ultimate death. Mathews was originally charged with capital murder and tampering with evidence. If convicted of murder, he would have faced the rest of his life in prison without parole. That's what we thought we were going to bring to you, that trial. But then on the eve of trial, those charges were taken off the table because Mathews entered a slow plea to the lesser included offense of injury to a child by omission, meaning he's pleading guilty, but a jury, not the judge, will determine punishment. The jury has wide latitude here. The penalty can range from probation to a life sentence. Today is day 2 of that penalty phase, and you know what I'm going to say? We're going live right now. Okay, I'm also here with trial attorney Andrew Cherkasky to break down what we're seeing. Andrew, good morning to you. What we're seeing here is very interesting because there's almost questioning that's happening of witnesses that would never be permitted in a trial phase. You tell me if I'm wrong here. The idea of asking this investigator about this is the most difficult case you've ever worked on, or this one's different than all the rest, that would be improper during a phase where the jury has to determine if a defendant is guilty or not. Here, he's already pled guilty. They have to determine his punishment. I'm curious your thoughts on this kind of hybrid model, what we're seeing right now.
Well, when it's a sentencing-only case, it's an interesting mix because you're presenting the facts as they are, the facts that would have come out during the finding stage of the trial, but you're also able to interweave the more aggravating facts, the things that make this crime especially heinous or the ones that justify a higher request for a sentence. So you see it as a hybrid. It's a mix. The rules are generally relaxed. This is pretty normal in this type of case.
And it seems like it's an advantage to the prosecution here, Terry. They really get to do what they want to do. Defense, what can they do here since their client already admitted to a lesser charge? What can they cross-examine this witness? What can they actually do here?
They can cross-examine, and hopefully they can show that there is some discrepancy here. But I agree with you. It is to the advantage of the prosecution because they can clearly show that there is evidence here and there's more latitude here and they can say more, and it's all in front of the jury.
Yeah, and Andrew, look, he pled guilty to this lesser offense of injury to a child by omission. It seems like a great move on his part, considering there were capital murder charges, tampering with evidence charge, a lot at stake for him. This seemed to be a wise move by the defense. Why do you think the prosecution accepted it?
Well, because they can go ahead and do just this. They can still go for a very heavy sentence. They can still bring in their witnesses. A lot of times when I see one of these slow pleads or one of these pleads to a lesser, the prosecution may kind of give up. They might not put on as much aggravating evidence as would have come out in the finding stage. They're being quite strategic here. They're still putting on their best case. They're putting up their law enforcement agents, right, and they're not going to allow it to just be a defense case, which is what you see a lot of times in just a a sentencing case. People kind of mail it in on the prosecution side.
That's interesting. And well, let's see what the defense does, because they have an opportunity to cross-examine this witness right now. Let's go live. Andrew, this FBI agent who just left the stand, I want to talk about the last part of her testimony with the back and forth between the defense and the prosecution. Were they trying to establish whether or not the defendant really had pictures of this girl in the house, and whether or not there was dried blood there from earlier on? And what is the defense really trying to show here? Because their client already admitted guilt.
So there's a couple of things that are going on here. First of all, I've got to talk about a mistake that lawyers often make at the end of their examinations. Oftentimes we kind of devolve into this pettiness. We go back and forth over something kind of little. Are there pictures? Are there not pictures? Why aren't there pictures? That's a common trap that we all get ourselves into. So I think that's a lot of what was going on here. The bigger picture, though, is the prosecution's clearly going after the heinous nature of things. And the defense, I think, is trying to show that this was very difficult on the defendant as well, that as much as he's responsible for this, this is something that has really weighed on his conscience and something that he struggles with. We have the projection that he's going to testify or say something, so that's to come. But I think what the defense counsel is doing is laying the groundwork to show that this isn't easy for anyone, and that there's a lot of emotion that goes into this.
Yeah, as Andrew said, Terry, we believe that the state has a couple more witnesses, and then, you know, it's possible the defendant will testify. That's the plan. We don't know of other witnesses, but what will he say? What will he say during this penalty phase?
Yeah, I think he's going to try to show that he did care about both daughters, the birth daughter and the adopted daughter, and that he did have pictures of the child. They might not have been displayed at the house, and that he too is suffering. So I think the only thing that they can show for mitigating circumstances here is that there was feeling on behalf of the defendant and that he really does care about the child.
Yeah, it's a tough case, and in this penalty phase, it's going to be all in the hands of the jury. That's what the defendant asked for. He pled guilty to this lesser charge and put it in the jury's hands to determine his punishment, not the judge. Let's go back live. Wow. So, Andrew, this is big. The defendant waited 5 hours to call authorities, and he didn't even call the emergency number after Sharon disappeared. What do you think about that?
Well, I think the detective's taking a little bit of liberty that he typically wouldn't be allowed in the findings phase by kind of giving his commentary. I thought this was odd. It's unusual for somebody to do that. It was like a lost item. That's a little bit indulgent, but it does make a point. And ultimately, his foreshadowing, if that's true, turned out to be a correct presumption that there was something insensitive going on here. Now, the 5 hours, you know, I can, as a parent, understand. Maybe if a child's missing for a little bit, you think he's playing hide and seek, and you don't want the embarrassment of police cars rushing up to the house for an accident. But here, it's something so different. It just doesn't make sense what's going on in the defendant's head.
Yep, and obviously this jury has a big decision about what his punishment will be, because he did plead guilty to injury to a child by omission. It's a lesser offense, but it does carry with it life in prison with the possibility of parole after 30 years. No, the long stretch right there. Detective Victor Diaz is explaining what the defendant first told him, but Terry, we all know that is not true, is it? That he left his daughter outside after she refused to drink her milk.
We know it's not true because he's already pled to the fact that this was something that he did by his own hands. He did this slow plea, and he's agreed to a lesser charge. So we do know that he lied at the time.
Lying is not good for this jury to hear when they have to determine his punishment, is it?
I agree. I think that what the defense is going to want to show is the fact that this is a good father and that this was an accident. He didn't mean for it to happen.
Right.
But the fact that he's lying shows some intent there.
Well, Andrew, what does injury to a child by omission really mean, the charge that he pled guilty to?
It means that you failed to do something. It's the absence of good parenting. It's the absence of taking the action to protect a child. So it is a very favorable plea. It's a very favorable charge compared to a capital murder charge that was on the table before.
You think the jury's wondering why he wasn't charged with murder? I'm not sure what they know at this point.
I I don't know. I think that juries often are relatively intelligent, kind of have some intuition to what's going on. They're not there for a finding stage of the trial. I think they probably understand that there's a plea of guilty going on here.
Right, yeah. I mean, there's a lot for them to consider, and then it immediately goes now to the penalty phase. Now, what you're seeing right now is Wesley Mathews' recorded police interview. We have to take a break, but when we come back, maybe we'll have an opportunity to listen to this. It's always important for the jury to hear a defendant in his or her own words, whether they take the stand or they're in a recorded interview. So this is the opportunity that we're waiting to see, and it's a lot at stake here. This is just one of the two main trials we're focusing on. We're also keeping a careful eye on Scott Nelson. A lot happening today. Stay tuned here on Law and Crime. We'll be right back right after this.